Okay, so great that you could join us for this call. This is hopefully the first in a series of events that we'll be doing in the coming months. And we hope to have a range of interesting events for the OGP Europe community. And this kind of broad topic of EU legislative and policy topics that are relevant to open government is one key theme we want to address. And the focus this time round will be on two key pieces of digital governance legislation, the Digital Services Act and the AI Act. But we do hope to have other webinars in future, which may look at other open government themes. And this is part of our EU strategy, where we're trying to make a better connection between our OGP national processes in Europe and the relevant pieces of EU policy and legislation, because they are highly interdependent, as you all know. And we want to make sure that you, as our contact points in the national OGP processes, have all the information you need, including on subjects which might not be your specialism. So this call is very much oriented towards people who are not technical specialists in this area, and to help us all build up our knowledge of what is sometimes quite a technical area of work, and also to think in particular about what a best practice version of the implementation of this legislation could mean from an open government perspective. So how can we embed the principles of open government in the way in which these pieces of legislation are implemented, and what could that mean in terms of OGP national action plans, and also in terms of the OpenGov Challenge, which I'm sure, as you all know, is our new initiative to boost ambition across the partnership. I'll come back to that at the very end and say a little bit more as a reminder about the OpenGov Challenge. But we're delighted to be partnering with the Centre for Democracy and Technology for this call, and we're really going to lean on them for the technical expertise around these two key pieces of legislation. And we are also going to have several inputs following CDT's presentations from speakers who are working at national level on the implementation of either one or both of these pieces of legislation. So we have two colleagues from CDT joining us. And they're both going to present one after the other, and then following both the presentations, we will have an opportunity for questions and for discussion. So David Klotsonis is a Policy and Research Officer at the Centre for Democracy and Technology. He works in the Online Expression and Civic Space program, where he focuses on research and advocacy on the Digital Services Act and the regulation on the targeting and transparency of political advertising. And David's colleague, Laura Cabrera, is Counsel and Director of the Equity and Data Program at CDT, where she leads the work promoting the effective protection of fundamental human rights in the implementation of EU legislation regulating new technologies. Her work focuses on identifying the adverse impacts of artificial intelligence on human rights and the regulatory or policy gaps that enable them, while working closely with affected individuals or communities to map effective solutions. So they sound like the perfect people to talk us through these pieces of EU legislation. So if there are no procedural questions, let me know in the chat if you're having trouble, for example, with the translation app. But otherwise, we'll proceed. So David and Laura, over to you. You have about 15 minutes each to present, and then we'll have some questions from participants.
Thank you for having us, Paul. I'm now just going to go ahead and share my screen. So from now on, if there's any logistical issues, please feel free to cut me off, as I won't be able to see it anymore. So as was mentioned, I'm a research and policy officer at CDT, where I work in the Online Expression and Civic Space program. And one of the main files that we deal with is the Digital Services Act. So in this presentation, I'm going to be giving a brief background, explaining who the DSA actually tries to regulate, how it tries to regulate it with a risk-based approach, and then briefly give an overview of what is the current state of play, what opportunities and risks there are for the future, and what the open government lens can teach us when it comes to the enforcement of the DSA. So the Digital Services Act, or DSA for short, was a landmark EU regulation. And it came with a realization from the co-legislators that fundamental rights needed to be protected in the online space as well, while at the same time also making sure that we promote a digital single EU market. This would be so that companies have to abide by one set of rules instead of 27 different rules. Although it has been applicable to so-called very large online platforms and search engines since April 2023, it fully entered into force in February of this year. Fundamentally, the DSA tries to do three things. The first one is that it increases transparency, or simply put, it allows us to look at the underbelly of digital platforms to understand exactly how they operate. With this increased transparency also comes accountability to make sure that people are protected from illegal or harmful content online. This also means that their fundamental rights and safety are ensured in the digital space. So who does the DSA actually regulate? Well, simply put, it regulates all online intermediary services, starting with basic internet access providers and domain name registrars, as you can see at the bottom of the pyramid, but also cloud and web hosting services, then what we're more familiar with, online platforms such as marketplaces, app stores, and social media platforms. And at the very top, we have very large online platforms and very large online search engines, or VLOPs and VLOSes for short, which is a bit of a weird acronym. The idea here is that as you move up the pyramid, you are subject to increasingly more and more obligations. And the rationale behind that is that the bigger the platform that you're operating, the bigger the risk for society. This is what's called the DSA's risk-based approach. And at the core of this risk-based approach are annual risk assessments. That means that very large online platforms and search engines, which are designated based on the amount of users and market power that they have. So if you have more than 45 million active monthly users in the EU, you're designated as a very large online platform. It's roughly 10% of the EU's population. These platforms have to submit yearly reports where they, first of all, identify and then evaluate what systemic risks their services could pose. And once they've done that, they have to come up with adequate and appropriate mitigation measures. The DSA sets out four main categories of systemic risks, including illegal content, risks to fundamental rights, democratic process, civic discourse and elections, and risks to public health, mental well-being, and gender-based violence. Although this is not a comprehensive list. Once these reports are finalized, they are then submitted to the European Commission so that it can evaluate whether they're fully compliant with their obligations. And to substantiate this, there's also an audit report, which is conducted by independent auditors who also try themselves to evaluate the quality of the risk assessments. Supporting all of this, just to give you an idea, are a set of transparency obligations for platforms, including the reports that I just mentioned, but also transparency reports, a transparency database, data access for researchers so that some things can be studied more in depth, and a DSA whistleblower tool, which can allow people to share confidential information without suffering penalties. And the proverbial stick to all of this are fines. So to make accountability real, the European Commission has the possibility to apply fines up to 6% of global annual revenue if it finds that a company is in infringement of the DSA. And it can even apply interim measures where the services of a platform are temporarily suspended in the EU. In this slide, I have tried to map out the enforcement structure of the DSA, and it might look a little bit complicated at first, but it's actually relatively straightforward. So at the top level, essentially there are two levels. There is the EU level enforcement and the member state level enforcement. At the top left, we see the EU level enforcement, which is through the European Commission. The European Commission is responsible for enforcing the DSA on the previously mentioned very large online platforms and search engines. This includes things like sending requests for information, where they might need additional information to decide whether they need to open an investigation. then actually opening investigations and then making decisions on whether there has been a potential infringement or not. The European Commission is also responsible for publishing secondary legislation, such as delegated acts and guidelines, which essentially further explain some parts of the DSA that might need clarification. Then we have the member state level at the bottom left, where national authorities, so-called digital services coordinators, are responsible for enforcing the DSA within their jurisdiction. This includes things like handling complaints, investigating potential violations, applying penalties, and crucially, vetting trusted flaggers and vetting out-of-court dispute settlement bodies. One could say that the digital services coordinators at the national level are not directly responsible for the very large online platforms or search engines, because that is the remit of the European Commission. This was done in an attempt to fix some of the mistakes that were made with GDPR, where a lot of the very big companies were regulated at the national level, and this led to certain issues. At the center, however, we have the European Board of Digital Services, and this is where the digital services coordinators from each member state come together with the European Commission. The European Commission chairs the European Board of Digital Services, and each member state sends a representative from the digital services coordinators. They're organized along different thematic groups, but essentially they have two sets of functions. The first one has to do with enforcement, which comes in the form of general cross-border cooperation and potentially joint investigations. And the second has to do with secondary legislation and guidelines, as well as opinions and recommendations. Here it is crucial to understand that the digital services coordinators and the European Commission work very closely together for the overall enforcement of the Digital Services Act. So even though one is theoretically at the member state level and the other one is at the EU level, their cooperation is really essential for this to work. I have also added, as you can see, citizens and civil society at the left of this chart. And the reason for that is that they're also fundamental to the enforcement structure of the DSA, even if it's not so explicit in the legal text. That's because ultimately it is citizens or users that are affected by the harms of many digital platforms, and it is then civil society organizations, many of whom directly represent those users, who can really help in gathering the necessary evidence to move on to investigations and potentially conclude with infringement. So just to give you a brief overview of where the enforcement currently is at the EU level, things have been moving quite fast. The European Commission has sent 62 requests for information, has opened a number of investigations, and even published preliminary findings in the case of one platform, which is X. At the member state level, things have been moving a little bit slower. And member states took longer than expected to officially designate their digital services coordinators. This led the European Commission to open formal infringement proceedings against 6 of those member states for not having designated a DSC in July. This is crucial for a number of reasons, as I explained in the previous slide. As I explained here, the interplay between the digital services coordinators and the European Commission within the European Board of Digital Services is really crucial for the effective enforcement of the DSA overall. Therefore, as long as DSCs are not officially appointed and are not given sufficient resources, this can have important side effects. For example, we see that only 10 trusted flaggers have been vetted so far. This is due to a number of reasons, but also partly due to the fact that not every DSC is up and running quite yet. So what can we learn from the open government approach to this, and what opportunities for improvement are there? The first one relates to my last point, is that DSCs need to be officially appointed and sufficiently resourced. This is to make sure that they are independent, fully independent from the outset, and that they have sufficient capacity. And the reason for that is that they are fundamentally the main points for stakeholder engagement at the national level. And whether we're talking about linguistic expertise or specific subject matter expertise, it is really crucial for the DSCs to be able to channel whatever evidence is coming through organizations at the national level, to channel that to the European Board of Digital Services so that it can feed into requests for information and investigations, and to really harness this cross-border cooperation. Then moving on to transparency, even though the European Commission is subject to the usual rules of procedure, so like publishing information, minutes from meetings, decisions, etc., there's always room for improvement. One way to do so would be for the European Commission and DSCs to publish public timelines with forthcoming enforcement actions. This would again make it easier for civil society organizations, often organizations that are directly representing citizens, to engage with the enforcement process. Another point of transparency is that the risk assessment and audit reports that I mentioned previously are first submitted to the European Commission, and then a redacted version of those is made public. And in November, we're expecting the first round of risk assessment reports and audit reports, and we would really expect them to be at the highest level of transparency possible, of course, taking into account trade secrets and confidentiality agreements. And finally, a crucial point has to do with the Board of Digital Services itself, where it would be useful to establish a mechanism for civil society consultation, which again can facilitate stakeholder engagement at national level. Essentially, by being part of the procedures within the board, there can be multiple channels of communication between organizations, the DSCs, and the Commission. And this is where Open Government Partnership actually has a lot of experience and has gathered a lot of evidence of what different kinds of structures and mechanisms we can draw inspiration from to make that a reality. But ultimately, for the DSA to be effectively enforced, we'll need to leverage all stakeholders, and this would be one way to do it. So with that, I'll pass on to my colleague Laura. Laura, if you want, I can keep flipping through the slides, or I can let you share your screen and then you do it yourself.
Thanks, David. I think if you don't mind, it'd be great if you could keep clicking through the slides.
Yeah.
Excellent. Well, hi, everyone. It's a pleasure to be here with you today. As Paul already mentioned, I'm Laura Lazaro Cabrera. I'm the Council and Program Director for Equity and Data here at CDT Europe. And today I'll be taking you through a quick whistle-stop tour on the key rationale and provisions of the AI Act. So without further ado, and being mindful of time, the AI Act, as you all know, is the world's first landmark comprehensive attempt to regulate artificial intelligence. And certainly it has precedent-setting value for several legislative initiatives all over the world, for better or for worse. And something that's quite unique about the AI Act, not just related to the fact that it's the first ever law to deal with the subject matter, is the fact that it's quite unique also from a legislative standpoint from an EU perspective. So the AI Act, you might have heard it described at times as a hybrid piece of legislation. And the reason for this is that it combines aspects of product safety legislation, a well-established area of EU law, as well as fundamental rights. And this is made evident by the fact that the AI Act has two legal bases. Any legislative proposal in the EU must have at least one, typically found in the Treaty on the Functioning of the European Union, a foundational treaty in the EU. But the AI Act has two, one pertaining to the internal market regulation, and another one taking root in data protection and privacy provisions set out in the TFEU. And this hybrid nature, combining traditional market regulation with fundamental rights, is what runs through the core of the AI Act, and also what runs through every single one of its provisions. And we can get into that more throughout the questions, but hopefully it will become apparent from the rest of the presentation. So the AI Act, as you might already know, was adopted earlier this year and entered into force about 3 months ago on the 2nd of August, 2024. Oh, you jumped the gun there a bit, David, I think. Thanks. And despite the fact that it's entered into force already, it's not yet become applicable. Its first few key sections start becoming applicable next year as of February 2025, starting with the provisions governing prohibited AI systems. And then that will take us through to a horizon of August 2026, 2 years after entry into force, bearing in mind that some provisions will only apply to certain types of AI systems as late as 2030, depending on who it is deployed by and in what context. Next slide, please. So getting into the rationale of the AI Act, it is also a risk-based legislation. So here it's interesting to start drawing parallels between the AI Act and the DSA. And it's risk-based in the sense that the higher the risk, the stricter the rules. If you come away with one thing from this presentation, let it be that. And there are two risk frameworks applicable depending on whether the AI is an AI system or whether it is a general purpose AI model. And these are the two things that the AI Act really tries to govern. When it comes to AI systems, the AI Act recognizes 4 categories of risk, with the highest one being AI systems that pose an unacceptable level of risk. And these are outrightly prohibited under the AI Act. So some examples include the use of web scraping for the building of facial recognition databases, the use of remote biometric identification, for example, facial recognition, by law enforcement in publicly accessible spaces, and the use of emotion recognition in certain contexts, but there's many, many more. Next, we come to the high-risk category, and this is the category that comes with ostensibly the most obligations under the AI Act. AI systems posing high risk are defined in Annex 3. So this section is not as prescriptive as the section dealing with unacceptable risk. Instead, what the AI Act looks at is at the context of deployment. So an AI system will be considered high risk if it's deployed in the law enforcement context, critical infrastructure context, or even democratic processes context. And here, if an AI system is high risk, it will be allowed, but it will be subject to many, many obligations, not least a conformity assessment, which is an evaluation of the AI system's compliance with the AI Act at large. And in some cases, depending on the identity of the deployer, we'll also be looking at a requirement to carry out the fundamental rights impact assessment. Next, we have those AI systems posing a transparency risk. These are a minority, and these are largely permitted with very few restrictions that just have to do with the provision of additional information. And finally, we have those AI systems with minimal risk. In essence, any AI system not captured by the preceding 3 categories will be considered minimal risk and will be permitted without any restrictions in the AI Act. So there is a scope for, well, rather, there are AI systems that will not be governed by the AI Act at all if they don't meet any of the preceding risk categories requirements. Now, general purpose AI models are governed a bit differently. There are rules applicable to general purpose AI models, regardless of whether or not they pose an identified type of risk. There is an opt-out for these, depending on whether or not the model is subject to an open source license, but by and large, these obligations must be complied with, and there is an additional set of obligations for general purpose AI models that pose systemic risk. This is a concept defined in the Act, different from the concept of systemic risk in the DSA, and here additional obligations include risk assessment, mitigations, as well as cybersecurity measures. Next slide, please. Now, I'd like to cover some of the key taxonomy items in the AI Act. So in the AI Act, you're governed as either a provider or a deployer. Providers have the bulk of obligations in the AI Act, but deployers also have to comply with many themselves, and these categories are not watertight. A deployer can become a provider in some circumstances prescribed by the Act itself. So providers will have to carry out not just the building of and developing of technical documentation, but also the conformity assessment that I mentioned before, a quality management system, as well as providing robust instructions for use for downstream actors, including deployers. And deployers in turn have obligations in connection with human oversight and monitoring, notifying individuals as well as other transparency measures, and fundamental rights impact assessments if they are public authorities. Next slide, please. Now, the AI Act has quite a complex enforcement structure at 2 levels, a regional level and then a national level. So when it comes to the regional level, the preeminent entity is European Commission, and specifically the AI Office, which was created prior to the AI Act's adoption to essentially oversee all aspects of implementation and enforcement. Next, we have the AI Board, which is, unlike the DSA's board, made up of member state representatives. So it's key to draw that distinction. It's not digital services coordinators, like in the case of the DSA, but it's instead representatives of member states. The AI board has a very wide mandate, which essentially looks to ensure coordination among national authorities, but also at regional level between national authorities. Next, we have two independent entities, the Scientific Panel of Independent Experts. Those of you who have been following this landscape might have seen that in the last few days, the Commission published a draft in the Implementing Act on exactly this topic. So now we know there are likely to be no more than 60 different experts making up this panel. And really, its role is to oversee general purpose AI models at regional level. And the panel actually has powers bestowed onto it by the AI Act to not just require the Commission to request documentation from a general purpose AI model provider, but also they can issue qualified alerts to the Commission directly to start investigating a general purpose AI model. Lastly, we have the advisory forum, which is a forum that will be made up of civil society, academic, private sector, and public sector representatives. There aren't any details yet as to what it would look like, but the idea is that there's parity among representatives. The only challenge is that this advisory forum will only be able to provide information upon requests, so they don't have powers to compel the Commission to do anything. And at national level, we're looking at a three-layered enforcement structure. First of all, the market surveillance authorities. They have been in existence for a long time, as this is a figure that pertains to product safety legislation. The AI Act, however, requires for there to be at least one market surveillance authority to be appointed as the point of contact for AI. There is a sense that many of these authorities will likely be data protection agencies, but of course, nothing in the Act precludes there being several. And this entity will be the one in charge of overseeing compliance with the AI Act. Then we have notifying bodies and notified bodies. This terminology can be a bit confusing, but essentially what these are the national level bodies that will carry out the conformity assessment exercise. So the obligation is on providers to ensure that there is one when it comes to their AI system, but there needs to be an independent entity, say an independent auditor, that checks that indeed the provider is in compliance with all the provisions of the AI Act. So that's a role that those fulfill. And lastly, we've got fundamental rights authorities. They're not recognized as an enforcer by the AI Act, but they're still very relevant to the extent that they have powers to request the Market Surveillance Authority for information on certain AI systems or general purpose AI models when the issue falls within their mandate. Next slide, please. So reflecting on the AI Act through an open government lens, there is quite some alignment between the AI Act's objectives and I would say open government values. So the AI Act is all about increasing transparency in the use of AI systems and its risks and implications, enhancing accountability through a multi-tiered governance structure, but ultimately protecting individuals from risk to health, safety, and fundamental rights. And I'd like to look through specific case studies of where these values might come into play and help strengthen the AI Act. Next slide, please. So the first one is transparency. Many have said that the AI Act didn't go far enough in ensuring disclosure of AI systems use and their risks. So one of the key provisions of the AI Act is to list in an EU-wide public database high-risk AI systems. However, those high-risk AI systems deployed in the migration or law enforcement context are excluded from the public section of the database, and they will instead be put in a confidential, non-publicly accessible section. So one way to really take the open government approach further will be for states to try and find ways to incentivize the publication of information in high-risk AI systems, even if they are deployed in these contexts that might be considered sensitive. Another aspect of the AI Act where transparency could play an important role is on the disclosure of fundamental rights impact assessments. So in the few situations where they need to be carried out, there's no obligation created by the AI Act to make those public. It would be good if states could at least investigate supporting the publication of the entirety of fundamental rights impact assessment and reserve or redact some sections based on national legislation seeking to protect sensitive information. Next slide, please. Accountability is also a big item in the AI Act. And luckily, we not only have entities at national level, but also, in the form of market surveillance authorities, but also specialist fundamental rights focused organizations that can play a significant role. Here we have two deadlines for nominating. The first one, I think Silvana needs to. meet. So the first deadline that we're contemplating at the moment is November the 2nd, so just a week or so from now, to nominate and make public the list of fundamental rights authorities with powers under the AI Act. An open government approach would have governments perhaps comprehensively identify these authorities and ensure that they're not leaving any out. So here we'd be talking about equality bodies or national human rights institutions. It's key that the states are nominating as many organizations as possible. And then the appointment of market surveillance authorities. Here, like in the case of the DSA, resourcing is a valid concern. So ahead of appointing these entities by the August 2025 deadlines, it'd be good for member states to ensure that there's a clear mandate for these organizations and adequate resourcing so they may communicate with civil society. And last but not least, next slide, please. We've got participation. So here, the key concern is ensuring that the development of national legislation in connection with the AI Act is subject to open and robust consultations. There are, in the AI Act, provisions to enable member states to use prohibited AI systems following very stringent requirements. For example, the prohibition to remote biometric identification is subject to exceptions, but states willing to avail themselves of those will have to enact legislation essentially saying that they can use these exceptions. We are very worried, as is the rest of civil society, that these new laws may be used to undermine the right to privacy. So here, a key aspect to ensure that the laws don't go too far and that the exceptions are thoroughly observed in the AI Act would be to ensure that any legislative effort is accompanied by a robust consultation of relevant actors in civil society. And that concludes my presentation. Looking forward to your questions.
Okay, thank you very much, David and Laura. That's a really super comprehensive overview of both these pieces of legislation and breaking it down into understandable detail. So now we have about 10 or slightly more minutes for any questions that people have or comments that you want to make to open a bit of discussion on this. So David, perhaps you could stop sharing your screen so we can see everybody. And if you're happy to put on your camera for this section, that also makes for a better discussion. So I'll open the floor. Please raise your hand using the raise hand function on Zoom, or you can also type your question into the chat. I should apologize because the translation function that we promised doesn't seem to be working due to some glitches related to the registration process for Zoom. So apologies if you were hoping to make use of that. So yes, open the floor for questions or comments. I'm happy to wait out the silence. I know that somebody must have a question or a comment. If you'd also like to share something about, we will have some presentations from the national level coming shortly. But if you're not part of that already and you did want to share something you're doing at national level, also feel free to jump in to share. Very quiet bunch of people today. Maybe my OGP colleagues want to kick us off with a question or two.
I can ask a quick question just to get things going. So I'm interested if you're seeing any kind of emerging practice from from kind of nation states that looks particularly interesting in how they're planning to implement the two acts, or is it still too early to tell?
Perhaps I can start answering this one, Laura, and if you want to add something, feel free. So for the DSA, we obviously, depending on the member state, DSC, so digital services coordinators, have been appointed different levels of capacity. And Ireland is famously a hub for many very large online platforms. And so the Irish DSC, which is called CNAM, is rather well resourced. And out of CNAM, we've seen a number of initiatives. Most recently, they published a set of guidelines. So it's essentially a 20-page or so guide where they really help organizations that want to apply for the trusted flagger status. And they give details as to every step of the process, what kind of obligations they would have to comply with, etc. This is particularly useful because, having spoken to many organizations at member state level, there's a lack of clarity as to what is expected, and a lot of them are not even aware that this is an option. And so publishing preemptively this kind of guide, I think is the best practice that could be mirrored by many other DSCs as well, and we hope to see more of that in the future.
Just to comment on that question, I mean, the AI Act is a much, much earlier stage of implementation. But so far, what we're seeing in some states, it's not so much the government's taking action, but for instance, data protection authorities coming out and saying that they feel that the role of market surveillance authority should fall onto them, that they should be the ones taking charge of overseeing AI systems and general purpose AI models. And I mean, in terms of examples that we know of, there's a French example, but also the Dutch example, where the data protection authorities have said that they feel that they have the capacity and maybe even resourcing to be able to fulfill this role. And that is something that we're keeping an eye out for, because there's no obligation in the AI Act for it to be data protection authorities. But certainly because of the important fundamental rights element that goes through the AI Act, there are many data protection authorities that feel that it's only appropriate for them to take on the mantle of national regulators. So it's a space to be monitored for sure.
Maybe just a quick follow-on question from that, Laura, is so in Spain, we've seen the establishment of a new body in association with the AI Act. I'm just wondering if there are other countries who are going down that route and planning to establish new bodies, or would the majority be designating data protection authorities or others?
The example that I know is also the Spanish one. It will be, I think, challenging for member states to make this determination, owing to the fact that there is already an established body of market surveillance authorities. So it might make most sense, depending on what their mandate is, to already designate a market surveillance authority, and in addition to their existing mandate, add the AI Act dimension to it. But then that will depend on every single member state's willingness to, well, approach the issue and also desired focus. So those member states that might want to prioritize fundamental rights may go with data protection authorities, but there may be others that may be more focused on the product safety element. And so they might designate an already existing market surveillance authority. And of course, that comes with a price tag. Every single time they have to create a new authority, it's additional resourcing.
Okay, thanks, Laura. What might be useful if you are able to share the slides? I don't know if there's a shareable version that you could put in the chat or anything like that. I mean, certainly we can circulate them afterwards, but I think with topics like this, it can be helpful for people to be able to browse through the slides at their own pace, because that can help to provoke questions and discussion as well. So if you do have a shareable version, maybe you could put a link in the chat, or upload the file even, if you don't mind. We do have another discussion section later on, so if there aren't any other questions for now, we might move on to the next set of inputs, and people can save up any questions or continue thinking of questions in the meantime. Maybe they want to browse through the slides. So I think I'll hand over to my colleague Sarah at this point, who's going to introduce the second part of our discussion and to moderate the discussion as well. Thanks, Sarah.
Cool, thanks, Paul. Yeah, so maybe this section will create some more questions as we're going to move from this very broad, very wide EU generic perspective, and we're going to narrow it down a little bit and hear some inputs from organizations working on a much smaller scope on the national level. So start thinking about those questions already. Like Paul said, we have time in the end. Our three presenters have been asked to share some flash perspectives, so quickly, and we'll go one at a time, all three. So please save the questions, the comments until they've all shared, and then we'll have discussion afterwards. So first up, to kick us off, we have Julian Jauch from the Stiftung Neue Verantwortung in Germany. And he is a project director there in the field of strengthening the digital public sphere. His work focuses on questions around tackling disinformation and regulating tech platforms. And today he's going to share a bit more about the DSA implementation with an emphasis on Germany's implementation of the Act. So Julian, I see you.
Thank you. Thank you very much for the introduction. Thanks for having me. Also, many thanks for everyone being here and the presentation so far. That was already helpful and interesting. I hope you can now see my slides. Yes. Okay. Again, thanks for having me. As mentioned, I will try to just provide a brief overview of the situation with the DSA enforcement in Germany. Before I start, I can already say that the enforcement actions here at the German level have been minimal so far. So there's really not a lot of empirical evidence or experiences that I can share. It's still very early in the process. There's a couple of actions that have been taken, like, for example, a couple of complaints have come in and a trusted flagger has been certified, but there's really not that much. So that's why I wanted to focus a little bit on the overall governance structure that's out there, and maybe highlight one or two special things that could be of interest in the open government perspective. So as mentioned, I work at Stiftung Neue Verantwortung. Actually, now we called Interface. We recently rebranded. We're a not-for-profit think tank working on tech policy issues, with my focus being very much on platform regulation and the DSA. This is the topic for the next couple of minutes. It's great that I don't have to explain it because David did such an amazing job of explaining everything. I think I will just repeat what he said about a lot of different actors working together on enforcement. I think this was one of the key takeaways from his presentation. I can really highlight that. Civil society, researchers, the European Commission, and of course, the topic for me here, national regulators, which have a role to play in DSA enforcement. And so, as David mentioned, one of the key things to note about enforcement is the Digital Services Coordinator at the national level, which has to, as the name suggests, coordinate the regulators at the national level, but also has very important oversight tasks in and of itself. So in Germany, the DSC is currently being set up at the Bundesnetzagentur, the Federal Network Agency, which has traditionally been a telecoms regulator, among other things. And this DSC will, for example, be in charge of the complaint mechanism, of the transparency reports, receiving transparency reports from platforms. They will certify trusted flaggers and out-of-court dispute settlement bodies. They will be in touch with the national level, the EU level as well. One of the requirements for the DSC is that it needs to be independent, as you might know, and how Germany solved this was by making the DSC an independent work strand in the German Federal Network Agency. So you see the organizational chart of the Federal Network Agency here, and on the very right-hand side, highlighted in red here, is the DSC, the DSC in waiting, so to say. And as you can see, it's not connected to the president of the agency. It's not connected to any government ministry. You can make the argument that this is still not independent enough and a completely different agency would be better. But this is what legal experts and policymakers in Germany agreed upon, and it's, for German comparative standards, a fairly independent and fairly unique setup. So this is one of the things that I wanted to share as one of the governance aspects of the DSC in Germany. Now, as the name suggests, as I mentioned, there are other agencies in Germany also playing a role in DSA enforcement. For example, for data protection issues, there are some other authorities in play, and for youth protection as well. So what I want to highlight with this is the very important aspect of regulators from different policy fields working together on joint DSA enforcement. And lastly, one unique thing I wanted to share is, as far as I know, Germany is the only member state that has built a DSC advisory council. It's made up of civil society organizations, representatives from society organizations, business associations, and academic institutions. And it's tasked with consulting with the DSC, making recommendations to the DSC. And this is fairly new. I mean, obviously, there's other advisory councils in other fields, but in this platform regulatory field in Germany, this is new. They've only met a couple of times, so this will be interesting to follow what the council can actually achieve, because some of the tasks are a bit vague, in my opinion. So to close, just some open questions, maybe to stick with the advisory council first. As I mentioned, it's brand new. I think it's only met once or twice. So, you know, the specific task, the long-term outlook here, the role is as of yet unclear. A second important point that I can also highlight from David's presentation is resources. The German DSC has some staff already, but the actual budget and the actual bigger staff is still up in the air because German politicians are currently negotiating the budget for next year, and a lot of it will depend on how many people and how much money the DSC will get. Crucially, I think from a stakeholder management and government perspective is communication and coordination. It's this type of inter-regulator communication and coordination that's necessary, as well as communicating to the public. And lastly, related to that, to build this community of practice that David was talking about, that I mentioned again, you do need this structured outreach to experts from academia, from civil society, from businesses, from media, to have the expertise that you need to enforce the DSA. And this is another thing that I'll be watching, and I'm sure a lot of other people will be watching over the next couple of months to see how the DSC in Germany goes about this and is successful with that. I'll close with that. Thank you very much, and definitely looking forward to any comments or questions you might have from different contexts. Thanks.
Great. Thank you so much, Julian. That was very interesting. Living in Germany and not knowing a whole lot about it. So I have some questions to ask you later if no one else does. But for now, we will move on. I see Henrik is here. So our next presenter is Henrik Trasberg. Yes, is a legal advisor on new technologies to the Estonian Ministry of Justice. He's mainly working on trustworthy and human-centric uptake of AI in Estonia and the EU more broadly. He's also an intellectual property law lecturer at the University of Tartu, and we're very happy to have you here today to share more about the Estonian case. So the floor is yours.
Thanks so much, Sarah. Happy to be here. Since a nice introduction of who I am was already given, I'm not going to repeat that. But I have been working on AI Act negotiations in the EU Council and right now on the AI Act implementation in the national legislation. So in my couple of minutes here, I will focus on that part. And because I only have so little time, then I'm not gonna really try to give you any kind of a thorough overview of how we're planning to implement AI Act, partly also because we have not made any final decision yet. Rather, I will let's say, shoot out a couple of concrete observations that we have been made in the process so far. But few comments on where we are at. We are really still in an exploratory phase. We haven't made any decisions yet. Who will be supervisor? How will we develop the sandbox? How we're going to organize different elements of supervision. Most of our efforts so far have been trying to understand what exactly we're going to adopt international law, what not, and trying to also further understand what some of the relevant provisions mean in practice. But really big part of what we have been doing is also about how to be as effective as possible in AI Act implementation, because it's a huge file, it's a huge task. At the same time, our resources right now are really limited. There are quite a lot of budget cuts in the public sector. So the challenge we are facing is how to be really clever and utilize pre-existing resources and pre-existing competences already within the public sector. In terms of implementation choices, the question of how to govern the AI Act, we are actually testing different approaches, particularly concerning sandboxes. We already last year did exploratory sandbox and what we call the data panel to see how we could provide this kind of a centralized support service and how we could provide competences to other authorities in through like a centralized mechanism. And in addition, we have a couple of international collaboration projects to also test different forms of how to provide a sandbox, how to do competence sharing, and other elements of governance. So we have taken this kind of a testing-based approach at this stage, which maybe means we'll be quite late with the implementation, but hopefully it does give us a better chance to get it right. Now, in terms of collaboration and participation, which is, I think, very relevant for this forum here, one of our observations has been that companies, at least in Estonia, they like to really talk about AI Act, but at the same time, there have not yet been too many concrete preparations by the industry for adoption. So it's actually quite hard to get parties to chip in terms of, let's say, providing next level detailed input that goes beyond this kind of a general discussion and, like, let's say, philosophical discussion towards really specific implementation aspects. So so it does seem that many organizations and companies, might only wake up at the last minute. Therefore, one of the really big efforts of us right now is working on awareness raising. And the awareness raising is also really important from the perspective that one of the challenges we are facing is there's a lot of false understanding about what the AI Act does, because AI does create a lot of emotions and everybody has their opinions. And it's the same with AI Act. So particularly if you go to a business conference, there are really many claims that are not really true or which are solved in a very concrete way in the AI Act. And so we have been trying through podcasts, conferences, other fora to explain what the Act actually does and breaking some of the myths and create understanding. So that has been really at the forefront of our focus. Couple of very positive elements in terms of collaboration. Personally, I'm quite a big fan of what has happened with all of the EU big data economy regulations is that there are these umbrella organizations that have a dedicated teams, often based in Brussels, and which bring together companies from all around EU and also elsewhere. And in those organizations, we also see very analytical and very thought through, elaborate input, which has been valuable during AI Act negotiations, but also now in implementation. And this is true from the industry side, from civil society side, and basically we do get a lot of very valuable input that is through these umbrella organizations. And the last kind of a positive element about collaboration that we have been seeing is that we have had very great collaboration with other member states. Particularly, there is this kind of informal working groups where countries are openly sharing how do they approach the questions in AI Act implementation that we are all facing. And I think I'm seeing that more than I've seen it with other EU regulations, where like these questions have really brought the different people together, that also from the regulator side, from the ministerial side, etc. And this collaborative aspect between member states has been truly valuable. But yeah, so these are my 3 minutes of quick observations, and I will also gladly take any questions you might have. Thank you.
Great, thank you, Henrik. So we'll move on to our third speaker now, and then after that, open the floor up for questions. But feel free to throw your thoughts in the chat already if you're coming up with things and don't want to forget them. So our third speaker is, oh, I don't want to mess up your last name, is Jungpanich. She is the Director of Strategic Partnerships at Political Watch and a member of the IA Ciudadana Coalition, as well as the founder of AlgoRight, a collaborative network that promotes CSO participation in the field of AI. She's here today representing AI Ciudadana, which aims to expand spaces for public participation in the regulation and governance of AI. So thank you very much for being with us, and you have the floor.
Okay, thank you very much for the invitation. I'm very excited to be here on today with you. So as okay, I'm Jungpanich, and I'm the director of strategic partnership at Political Watch, and we are part of IA Ciudadana. It's a Spanish coalition, and it's composed by 16 organizations working on human rights, transparency, consumer and labor rights, digital rights, and racial justice. And our goal is to get much more citizens' participation on the governance of AI. No? In this sense, we offer our expertise to support and collaborate with public institutions on how to embed the open government principles in the governance of AI. And in these 5 minutes, I will try to share a brief analysis of the AI Act from the open government approach. So, and also trying to get it presentation as much useful and practical possible. I will finish with a practical call to action. So our analysis is that the AI Act has not reached an adequate standard of human rights protections, and there is not much room for civil society organizations' participation. Nevertheless, the AI Act established a mandatory
Ty, we've lost your sound. Sorry, your microphone seemed to stop working. Maybe you can mute and unmute again. No, it's not working. Maybe it's picked up another headset or something like that. Oh, yes, you're back.
Yeah, I'm back.
It's working now. Yeah, let's hope it
Okay,
stays.
and then where do you lose me?
Only about like 10 or 10 seconds, maybe.
Okay, so I'm not going to repeat everything. Okay, great. Let's see. So, I don't know. It's, okay, so I will say that our analysis is that the AI Act has not reached an adequate standard of human rights protection, and there is not much room for civil society organizations' participation. Nevertheless, the Act established a mandatory framework which, if properly implemented, it's a real opportunity to improve transparency and accountability and how AI systems are developed and deployed, especially in the public sector. We have done a deep analysis of the regulation, but taking into account the objectives of this workshop, I'm going to focus on participation and transparency. In regards to the first one, the first versions of the regulation were much more ambitious in regards to public participation, but in the last version, these opportunities were narrowed down. It's urgent to demand and establish clear structures and spaces for civil society organizations in the relevant institutions at European and national level. In the European level, no? Diverse civil society organizations should have a seat in the advisory forum to provide technical expertise and advise the AI board and the Commission. We also think that there should be fundamental rights experts in the scientific panel. In regards to the national level, Spain was the first country to launch the National AI Authority. It's called AESIA. It's the Spanish Agency for AI Supervision. But after 2 years of this announcement, there are no clear processes and spaces for civil society organizations to participate. And we have been trying to influence the government to be much more part of this of the design of this public entity, and also that to take advantage of the collective intelligence that and the expertise that we have as civil society organizations coming from different aspects and knowledge from different like fundamental rights, equality, racial justice, and so on. No? there is no, as Laura was saying in the presentation, it's we need more clarity and comprehensive about the different entities, because fundamental rights authorities, there is not clear who is going to be working exactly on NI and AI. And regarding the national level, some civil society organizations and citizens have been influencing the fifth national action plan for the open government. And there are some interesting inputs on how to improve the governance of AI, and we are waiting for the draft to keep working on this. No, regarding the fundamental rights impact assessment, we think that it could be a real tool to reduce the negative impacts of AI, but only if it includes the participation of affected communities. Otherwise, there is a real risk that we are going to end with a checklist exercise without any real impact. In practice, much of the implementation of the AI requirements will take place through the adoption of technical standards. So more and more diverse civil society organizations should be involved in this process. In regards to transparency, the Act introduced the creation of a database managed by the European Commission, in which high-risk AI systems will have to be registered. The database has limitations, but it's an opportunity for governments to tackle the topic of algorithmic registers at national level. Why is an algorithm register an effective tool to advance open government topics? Because the register is a necessary tool to guarantee algorithmic accountability. By bringing more transparency to the technical and policy aspects of the algorithm systems, they can help salvaguard fundamental rights, foster democratic participation, and make governments more responsible for their decisions. I'm aware that today you are listening a lot of information, and you need to process all of this, but let me finish with one concrete action that maybe it could be useful for your work. To achieve meaningful transparency is possible through algorithm registers, but it needs to be careful designed and implemented. In this sense, we are working on a report on how to do it. The report outlines the opportunities and limitations of the AI Acts database, presents the state of the play of algorithm registers in Europe based on a mapping of more than 30 registers that are developed or planned to be in Europe, and proposed 11 concrete policy and technical recommendations to design, develop, implement an algorithm register at the national level. The report will be launched in the coming weeks, and we really think that this knowledge is useful for you or for anyone interested to make the AI Act a better regulation to improve people's life. Thank you very much.
Thank you, Ty.
I don't know if you listen to me, because it says that my network is unstable, so I don't know if you listen anything of what I was saying. I hope so.
Yes, we got all of it, I believe. And thank you for telling us about the report that will be published soon. We'll keep an eye out for that. That sounds really interesting. All right, so at this point, I hope everyone has been thinking of questions or things to talk about. I know we don't necessarily need to be asking questions. We can just share what's going on in your country, what the current thinking around these issues are, and maybe have the perspectives of our speakers on those topics as well. So feel free to raise your virtual hand or type in the chat. I can also kick us off, but I'll give us 30 seconds of silence before I do that. Does anyone want to start?
Hi, I actually have two questions to our speaker from Germany. So first off, this topic is very new for me, so this might be something, I don't know, that's very simple to answer. But you mentioned that Germany was the only member state you're aware of that has an advisory council. And I was wondering if you could elaborate a bit more on kind of what prompted this, if you know about what prompted this, if it was kind of integrated into a broader strategy to institutionalize civil society participation, or where this came from. And I think the second thing is also if you know whether there's a kind of accountability mechanism built into this, that the recommendations are actually considered or heard, or if you could say a little bit more about what happens to these recommendations by the Advisory Council. Thank you.
Should I go right away, or should we collect some more questions there?
Maybe go right away. I don't think we have a lot.
Yeah, thanks for that question. start with the first one. Why do we have it? I do think it was partly because civil society pushed for it. I think there was a general openness in government for that, which was, of course, really helpful and kind of like the catalyst for everything. If that openness hadn't been there, obviously none of this would have worked. But there was a concerted effort by civil society people, full disclosure also by myself, to do this, and we worked on this, we made a suggestion, and there were a couple of organizations who wrote an open letter arguing why this would make sense and what could be achieved by it. So I do think this mix of like an openness with the policymakers actually writing the law and people in parliament, as well as the push from civil society made that happen. To your second point, that is actually one of the weaknesses that I see. There is not a good accountability mechanism. So it says, you know, as I mentioned in the presentation, it says you can make recommendations if you're in council, you can consult, but it's not very clear what the German DSC has to do with this recommendation. It doesn't even say that they have to take them into account, you know, so it's pretty vague. I don't want to be too negative about it because it's the first time, obviously, they're meeting and they're trying this with the DSC. But I think experience from other advisory councils show that if you don't have that very like clear accountability mechanism, it can be kind of tough. So a lot of it will actually depend on the motivation and the effort that the members of the advisory council put into this. And, you know, they're doing this for very little money, almost no money, basically in their free time next to their work. So this is another like structural weakness that I see. But this is also why I mentioned in the presentation that this is an open question, right? Like this is something that we need to watch over the next couple of weeks and months and years. And I personally think that we also need to be open in our evaluation. If we know that it's no good because, you know, it doesn't help the DSC, it doesn't help the members of the council, it needs to be reevaluated. I think the openness for that needs to be there.
Thank you very much.
Go ahead, Paul.
Yeah, so I kind of have a broad question. Hopefully this isn't too much into the philosophy domain that Henrik was warning about earlier. But I guess stepping back from both these pieces of legislation, they're both really critical topics, but they're both really critical topics that are drowned in technical language. And because they have such a potential fundamental impact on our societies, and we think of all the problems associated with, you know, online mis and disinformation, for example, and also with the potential problematic application of AI across a whole different areas of our lives and societies, a really critical challenge for all of us, governments and civil society together, is to widen the circle of people who are involved in these discussions and to make these discussions accessible. So what does anyone have any thoughts on that? And that's a question to any of our speakers, either from CDT or from the shorter talks later. Like, how can we, because even you know, at this level on this call today, those of us who are kind of generalists in open government are, I think, struggling to get our heads around some of the technical detail. So, you know, much less for members of the public who aren't even kind of involved in open government to any extent. So how do we go about that? Just
I can very briefly comment. I don't have a good answer, but I can reiterate that it's a huge task. It's so interdisciplinary. From one side, yeah, I am also a lawyer, and there are also many non-technical people who have to work with these incredibly technical domains, and vice versa also. And we are really, really struggling with being able to speak in the same language, also already within the government. And then if you extend that to being able to communicate with different participants that you would want to include, whose voice you want to hear, yeah, I don't have a solution. I just wanted to mention that we see it as a big challenge. We try to speak in simple language and try to be able to find ways to communicate, but it really boils down to ability of a specific person to be able to find the same language.
Julian, you get to hand up first. Go ahead.
Yeah.
Yeah.
Yeah, that's one of the key questions, no? But it's not a key question for a lot of let's say public servants and also tech experts, and that's why it's we are quite proud in Spain, because we have really building this coalition, trying to get like the expertise. It's not only from the technical side, it's not only for the ones that do the code, let's say in that way, on the tech companies. The expertise, when we're talking about society and the risk and fundamental rights, the expertise, they are not coming usually from the companies, and they are the ones that have much more power, much more influence on the government, because even in the government, it's our experience. It's when they say experts, they always think about tech experts, and it's like, no, but we need to balance. It's tech experts, but we also need transparency experts, public participation, human rights, and so on. And this is something that is being really, really difficult to explain and to accept, because even if they say that it's true that we need to like multidisciplinary approach and convening all the actors and so, but at the end, the ones that are sitting on the table are the tech experts and having like a real influence on this. So one of the things that we are working is trying to raise more awareness and also explain to people that are experts on their own field that they are equally important to be seated there, because sometimes it's not only to be part of the table, it's also to believe that your expertise coming from fundamental rights is equally important. And maybe I'm going to bring another reflection that we are having, and maybe it's an open question to all of you that are much more much more about the public institutions inside. It's about how to start working with not only with the digital transformation departments, or not only with the ones on open government. That's how to mix the teams, not to work together on this issue. And also, I'm asking you if you have experience on like this kind of like mixed teams within the governments, to start also working on the ones that on the topic that you were saying, no? And also with civil society, but at least to mix teams in this intersection. Thank
you. Okay, Julian, did you want to jump back in?
I can, but I've already spoken, so I don't know if any of the other speakers wanted to jump in. No, I just wanted to actually underline what others have said. I do think that is the critical question. I also don't have a solution at all, but maybe like some beginning of the approaches, and maybe the advisory council is one of those things, right? It can be something where you bring people from different parts of society together, and hopefully they find common language and they can overcome that barrier of, be they from the technical side or the policy side. Other options, I do think also this intermingling of government and others is interesting. There are some examples, as I'm sure you know better than I do, of some government agencies having fellowships that they offer for academics or even civil society people. I think this is interesting, an interesting approach of mixing policy sides and regulator and non-regulator sides, and also highlight what David mentioned, this type of structured dialogue and going from just ad hoc meetings to a more long-term structured system of exchange could also be promising. It's also more costly and it takes more effort to set it up, but it seems rewarding. It can seem rewarding if it's set up correctly, I think.
Thank you. All right, one last call for questions. All right, then in that case, I'll send it back to Paul for some closing thoughts.
Great, thanks, Sarah. Well, thank you, everybody. Thank you to all of our speakers in the first panel and the second. It's been a really great discussion. I do wonder if maybe the kind of technical nature of the discussion is one of the reasons why we haven't had a lot of questions, but lots of people have come. So it's obviously a conversation that's of interest, and it's something that we'll be trying to dig into more and more in the coming years. And we know that whatever happens in terms of EU legislation of relevance to open government does tend to flow through into national action plan commitments in the years beyond. So we're paying close attention to what that means, what like an open government best practice implementation of these pieces of legislation looks like, what kinds of reforms we might see popping up in national action plans, and making sure that we're connecting our members together so that they can learn from one another and collectively push that level of ambition. And in that vein, it would be good to just quickly close with a recap on the OpenGov Challenge, which is our flagship initiative for trying to boost ambition across the partnership. So we're asking all of our members to commit to ambitious commitments in at least one of the 10 areas that are within the challenge. Next slide, please. So these are the 10 areas. By way of reminder, I won't go through them all now because today we've been focusing on digital governance, but countries can take part in as many and submit challenges in as many of these different areas as possible. But looking specifically at the digital governance one, within which the focus is on AI, this is our challenge prompt for digital governance. So we're looking for our members to make commitments that strengthen transparency and public oversight of AI, automated decision-making, and data protection frameworks. There are several different kinds of reforms that might fit this headline challenge prompt. We couldn't fit them all on the slide, but a few that might be particularly relevant to the conversation we've been having would be creating or strengthening independent oversight agencies, creating public grievance mechanisms, and embedding human rights impact assessments. So, and as we've been hearing from the speakers today, whilst the overall legislative framework has been set at EU level, there's a lot of flexibility and possibility at national level to go further, and in the way that the different national bodies are set up or designated to play the key regulatory roles in relation to these two pieces of legislation, there are real opportunities to enhance transparency, accountability, and participation. You'll find online on the OpenGov Challenge website the full list of actions and reforms that fit within the scope of that challenge. You'll also find our OpenGov Guide, which has a set of recommended reforms and pre-existing examples from across the partnership, as well as links to resources from partner organizations that can really help you delve into this topic. So it would be really great if you could do one thing from this call today. It would be to take what you've heard back to your multi-stakeholder forum or back to your colleagues in government or civil society and have a discussion about what opportunities there might be to work up some commitments in this area, whether you've got a national action plan co-creation process underway or whether you're between action plans. The OpenGov Challenge provides ways to participate for any set of circumstances. So you can, if you're co-creating a national action plan at the moment, you can simply designate a commitment within your national action plan as an OpenGov Challenge submission, as long as it meets the criteria and the scope that are set out on the OpenGov Challenge website. Or if you're in between action plans, or even if for some reason, a piece of work is ongoing or planned, but it doesn't fit within the co-creation process, you can also submit a standalone commitment. So, and any statutory agency can do that. So they can submit a standalone commitment, and there's a form on the website for that. And all of the commitments that go in as OpenGov Challenge submissions will also go forward for consideration for the OpenGov Awards, which will be taking place at the Global Summit in Spain next year. So it'd be really great to see, especially given the summit is in Europe, some flagship commitments in this area when we all get to Spain next year. So please do reach out to your regional coordinator if you want to discuss anything, and we can try and provide support and connections where that might be useful. So I think that completes everything for today, unless I'm looking at Sarah to see if I've forgotten anything. So we have recorded this, so we'll make that recording available to people who weren't able to attend and for yourselves, so you can look back over it and look out for other events coming up in the coming months on other pieces of open government relevant EU policy and legislation, and also other aspects of open government process and relevant open government themes. We're hoping this will be the first in a series of more regular events for the Europe OGP community, so do keep a lookout for other interesting events coming up. Thanks to everybody for taking part, and enjoy the rest of your week.